Good evening, good afternoon, and good morning to all our friends and colleagues joining us from all over the world, including from Miami and Hong Kong. My name is Neha Dagley, and I'm a commercial litigation and arbitration attorney based in Miami, Florida, where I've been practicing for 17 years. I currently serve as chair of the Asia Committee of the Florida Bar's International Law Section. Today's webinar, Hong Kong Gateway to China, Miami Gateway to Latin America, is jointly collaborated between the Florida Bar's International Law Section and the Law Society of Hong Kong. Before we get started, please take note that in this webinar, you're automatically muted and in listening mode only. The chat room allows you to send chat messages to the hosts, panelists, and attendees. If you have any questions for the speakers, please feel free to type your questions in the Q&A box or after the presentation. If you need more detailed instructions, please reach out to our host. Now, without further ado, please join me in welcoming the esteemed Mr. C.M. Chan and Ms. Susanna Leone, who will provide welcome remarks to kick off our panel. Mr. C.M. Chan is the president of the Law Society of Hong Kong. He first joined the Law Society of Hong Kong in 2016, and he's qualified to practice as a solicitor in Hong Kong as of 1997 and in England and Wales as of 2002. Mr. Chan is now the general counsel of an investment company and a part-time consultant of a local law firm. Welcome, Mr. Chan. And next I will introduce Ms. Susanna Leone, who is the immediate past chair of the Asia Committee of the Florida Bar International Law Section and currently serves as the chair of the Europe Committee. Susanna is one of the founders of Leon Zun, a law firm based in Miami, Florida, and is licensed to practice law in Germany and in Florida. And now I will turn it over to Mr. C.M. Chan.
Thank you, Ms. Dagley. Ms. Leon, Ms. Dagley, distinguished speakers and moderator, members of the Law Society of Hong Kong and the Florida Bar, good day, good morning, or good afternoon, depending wherever you are. It gives me great pleasure to welcome you all to today's joint webinar. The Law Society of Hong Kong devotes much effort in creating international exchange opportunities for our member, both to maintain continuous professional development and to develop international connections. One way of fulfilling this objective is through establishing connection with overseas lawyers associations like the Florida Bar. We are happy to connect with our US counterparts by signing of MOU, Memorandum of Understanding, with the Florida Bar International Law Section in May 2019. The MOU signing not only provided an opportunity to formalize our commitments to collaborate and support each other, it also creates more opportunities for professional exchanges among our respective members. I'm confident that we will continue to explore innovative ways to foster collaboration and strengthen our members' exchanges through meetings, seminars, and visits in the future. Over the past 2 years, the COVID-19 has brought international travel to a near halt and stopped most of the physical activities. Unfortunately, we are able to remain connected unhindered by geographic separation with the help of technology. It is encouraging to know that over 130 members are joining us today to know more about how Hong Kong can be a gateway to China and how Miami can be a gateway to Latin America for doing businesses. Before giving the floor to the speakers, allow me to briefly introduce the bilateral trading relationship between Hong Kong and the United States and Hong Kong's legal system. Being the largest economy in the world, the US is one of the key trading and investment partners for Hong Kong. It ranked as Hong Kong's third largest trading partner, second largest export market, and sixth largest import market in 2020. When it comes to foreign direct investments, Hong Kong was the fifth largest destination for US investors in Asia Pacific. Reciprocally, Hong Kong was the sixth largest Asian Pacific investor in the US after Japan, Australia, South Korea, the mainland China, and Singapore. Major investment sectors included wholesale trade, manufacturing, real estate, and rental and leasing. As a leading international financial center, Hong Kong is one of the world's best places to do business. Our free trade policy and easy customs procedures make it easier for businesses and companies to operate. For instance, according to the Fraser Institute's Economic Freedom of the World 2021 annual report, Hong Kong was the world's freest economy since 1996. Among the 5 areas of assessment, Hong Kong continued to rank top in freedom to trade internationally and regulation. Hong Kong has a well-established legal system firmly based on the rule of law and independent judiciary. Under the principle of one country, two systems, on the one hand, Hong Kong is part of China. On the other hand, Hong Kong is a special administrative region with our own economic system and way of life remain unchanged for 50 years after the handover in 1997, i.e. 2047. Being the only common law jurisdiction within China, the tried and trusted legal system of Hong Kong is always a cornerstone of our success. Hong Kong's open door policy has successfully attracted legal talent from around the world, enriching the diversity of Hong Kong's legal services market. As of the end of March, there were around 11,000 Hong Kong practicing solicitors and 941 local firms, as well as around 1,500 registered foreign lawyers from 33 jurisdictions around the world and 82 registered foreign law firms in Hong Kong. In particular, there are 557 foreign lawyers and 11 foreign law firms coming from the United States. I should perhaps also mention that Hong Kong is one of the few jurisdictions that we maintain a split profession, a legal profession. We have, on the one hand, the barristers and solicitors. So there are around 1,600 barristers also practicing in Hong Kong. What's more, Hong Kong is a neutral dispute resolution venue with world-class arbitration and mediation institutions that are capable of providing efficient and reliable dispute resolution services, such as the Hong Kong International Arbitration Center and the International Chamber of Commerce, ICC. Robust legal infrastructure and financial system, a business-friendly environment, abundance of multi-jurisdictional legal talents, as well as close connection and cooperation with mainland China, provide the necessary high-end professional service support to foreign investors. These unique advantages have also enabled Hong Kong to build up its global reputation as a leading legal and financial hub. So please enjoy the rest of the webinar, and I hope that you will find the event informative and fruitful and would be interested in setting up your business in Hong Kong or expanding your business into Asia and China via Hong Kong. Thank you for your attention.
Thank you for that. Susanna, may we turn this over to you for some welcome remarks?
Yes, of course. Hello, everyone. Good morning to Florida. Good evening to Hong Kong. We are very excited to be here today and having this webinar with you. I could have not said it anything better than Mr. CM Chan already did in relating to our relationship with the Law Society of Hong Kong. I remember when we signed this agreement a few years ago, we were excited. Now we have this webinar. And I know that some of our colleagues were over there in Hong Kong and signed the agreement and they reported back. And we are excited to be here. And I think I don't want to say too much because we're already like a little behind in time. And I know that our speakers will basically present our Miami and Florida advantages and all related to our topic. So enjoy this webinar. Welcome everyone on behalf of the Florida Bar International Law Section, and we are excited to be here.
Thank you for that. Thank you for those warm and informative welcome remarks. We will now turn to our speakers from the Florida Bar's International Law Section. Professor Manuel Gomez is the Associate Dean of International Law and Graduate Studies and the Associate Professor of Law at Florida International University College of Law. Professor Gomez also has law teaching experience at other United States universities, such as Stanford and Iowa, and has been at numerous Latin American, European, and Asian universities, either as a guest lecturer, speaker, or visiting professor. Welcome, Professor Gomez. And then we have Ms. Tiffany Compress, who is a partner at Fisher Broyles, She represents US and non-US companies as an advocate in international arbitration and litigation, and she also serves as an arbitrator in international arbitrations. Tiffany has worked in the United States, France, and Italy as is one of only 51 attorneys board certified as an expert in international law by the Florida Bar. Welcome, Tiffany and Manuel. We are now going to hand this over to you for your presentation.
Thank you very much. We're delighted to be here. So what we thought of doing today, we have 20 minutes, right? Was or is actually to go over some of the major features that we think would be of interest to a Hong Kong lawyer or to a Hong Kong business entity or to a Hong Kong public official about what's attractive in Florida regarding foreign investment, regarding the legal system, regarding disputes, and how Florida is positioned, like Hong Kong, as a gateway jurisdiction. In our case, a gateway jurisdiction to the rest of the Americas and also to Europe. There is always a focus on Latin America and the Caribbean because of the geographical proximity, but we see, at least in South Florida, where we are located in Miami, that Miami is not only at the intersection of the Caribbean basin, but is also at the intersection of other parts of the world and the Americas. So with that in mind, the remarks that Tiffany and I are going to give will be always highlighting that unique position that Miami has. So the points that we have in mind cover very briefly on a bird's eye view some of the key points on corporate aspects, some of the key points on real estate, some of the key points, which is pretty much the summit of our discussion, because that's what we do, disputes, international disputes. And then we'll talk a little bit about hot takes. So I'm going to turn it over to Tiffany now, so she can start with one of these points. And basically what we're going to do is that we're going to alternate and try to make it as dynamic as we can. Go on, Tiffany.
All right. So let's start with the corporate side. And with Miami, you know, why has it become, and I'm stealing this from Professor Gomez, the LATAM lounge of the world? I really, really loved that expression because I think it's so apt for Miamian. And I am a homegrown Miamian. I moved there, my family moved there when I was 2. So I really grew up there and I've seen the city change unbelievably. I mean, it's unrecognizable from when I was a little girl. And you know, so really the question is, what makes it such a wonderful destination and what has made it become this LATAM lounge for the world? Well, Miami is in Florida, which has one of the biggest economies in the United States. It actually has a bigger GDP than Turkey, Switzerland, and Argentina. It's the most important city in the United States for Spanish language media. So I actually have a couple of cases right now related to Spanish language media because of that. Miami's home to one of the largest ports in the United States, Port Miami. It's the largest cruise ship port in the world. It's often called the cruise capital of the world. And it's also the cargo gateway to the Americas. So among the North American ports, it ranks second only to New Orleans and Louisiana in cargo tonnage that's imported from Latin America. So it's the biggest cargo importer or gateway for perishable products like fish, fresh fruit, and produce. So we really see so much import-export activity here. It's just, it's a little crazy. And I myself see that in particular because that's where my practice focuses. So I've seen firsthand how that has really exploded. It's very easy to form a business in Florida, which I think is why it's so attractive to business owners. And it also gives you the opportunity, kind of like Delaware and a few other really popular states, to not disclose the true ownership of the company. So that's something that a lot of companies find attractive. And a company can be owned or opened by a resident, a non-resident, a citizen, a non-citizen. It's very flexible, which also dovetails with real estate. Real estate is one of the biggest economic engines in Florida as well. In particular, in the mid-2000s, we had a huge explosion of the real estate market in Florida, and that has cooled a little bit. It's reheating again, as many of us know that have tried to purchase or lease property. But it's very much central to the economy. And because you can own a company, not disclose the ownership and all of these kinds of things, you also can own property in your own name, as a citizen, as a non-citizen, as a resident. And you can also buy property or real estate as a company or as a trust. And that's something that we see a lot in the United States and in Florida in particular. It's become certainly a place where a lot of wealthy people put their money, especially wealthy Latin Americans, where their currencies are so unstable, their economies are very unstable. So oftentimes they come and they invest in Florida, and they consider it a safer place to hold their money. And some of that issue regarding the disclosure of the true ownership of real estate is in the process of changing because it's caused some consternation. But the last thing I wanted to mention, which is something that's relatively new for Florida, is that it's really becoming a hot center for cryptocurrency. The governor of Florida has been very supportive of the mayor of Miami, who has made a huge effort to turn Miami into the nation's cryptocurrency center and fintech center. And it's been really fascinating to see this journey. We now have our own cryptocurrency, Miami Coin, and we host in Miami one of the largest crypto conferences in the world. And in fact, we are now tied with Los Angeles for the third biggest home of crypto startups, the first being Silicon Valley and the second one being New York. Or maybe those are reversed, but in any event, it's New York and Silicon Valley, and then LA and Miami are tied for number 3. So that's something that I think is impacting a lot of the disputes that we're going to be seeing in the future in Miami. But generally, all of this business, the real estate, the import, export, the international trade, and so much international trade comes and goes through Miami. All of this really leads to a significant number of disputes. Professor Gomez, can you share with us a little bit about what we're seeing on the dispute side?
Of course, yes, thank you. So, as Tiffany mentioned, the economic activity, the incredible economic activity that occurs in the state of Florida, but focusing our comments on South Florida, sees a lot of transnational engagement regarding disputes. The real estate aspect is very important because there is a lot of foreign investors. There's a lot of foreign investors of a particular quality, in the sense that Florida does not prevent non-nationals, non-residents from buying property. There are some jurisdictions that impose restrictions. One of the unique aspects of the state of Florida is that you may be someone who doesn't even have, you don't have a citizenship, you don't have a residence, you have just tourist visa, or you have no visa at all, and you can still buy property in Florida. That immediately creates a transnational issue, at least potentially. So in terms of disputes, there are, and most of those investors are from Latin America and the Caribbean. There are also some Europeans. The COVID pandemic brought a lot of people moving from other parts of the United States to South Florida. So basically, the pandemic accelerated the interstate migration. And the reason why I mentioned that, and I went back to real estate a bit, which is one of the economic engines of the state, is that there's a significant amount of disputes tied to property in Florida. You have also corporate disputes between, say, two Latin American companies that own assets in Florida. So Florida becomes important because the assets are in Florida. Sometimes you have arbitral awards issued elsewhere, but the assets are in Florida. So there is a significant flow of recognition and enforcement actions in the state of Florida. Or sometimes you have proceedings being handled in before international arbitration tribunals, cited or not in Florida, that require evidence. So that also generates a lot for the courts. In more specific terms regarding the disputes, we have a very robust infrastructure for both litigation and arbitration. On the litigation front, there are obviously, the same array of courts that you would find in any other state in the United States. In case you don't know, the United States is a federal system. What means is that states also have their own court system. So there is this duality of state courts and federal courts. So depending on a variety of factors, the case or the dispute could be decided by a state court or could be decided by a federal court. In terms of arbitration, and let me say another thing. Judges in the state of Florida, in South Florida, are very well versed on foreign elements in their proceedings. There is a significant amount of activity that occurs in the litigation context that, because of its connection with foreign jurisdictions, demands that judges familiarize themselves with the legal systems of other jurisdictions. Also, parties oftentimes bring experts for the legal proceedings. So what could be considered as an advantage is the familiarity with foreign jurisdictions, the familiarity with civil law jurisdictions that you would find among judges, among practitioners, and also among parties. So there is an infrastructure that supports the globalization, so to speak, of a jurisdiction. In terms of arbitration, and I will say only a couple of things because I know that Tiffany also wants to add some remarks about international arbitration in terms of let's say international or both international and domestic dispute resolution. Is not only arbitration, it's also mediation. Florida is one of the big mediation states. What that means is that it has regulated mediation for a long time. It has established, credentialing for mediators and so on and so forth. Florida is also a model law jurisdiction and is also a jurisdiction that has been putting a lot of efforts in creating an ideal infrastructure for international arbitration. In Miami-Dade, which is the county where Miami is, there is a specialized court that oversees arbitration-related matters. There is also a robust community of practitioners, a very, very active community of practitioners that handle international arbitration matters, not only the usual suspect international law firms, but also mid-sized and small law firms and even solo practitioners who have distinguished themselves as premier practitioners. Some of the leading institutions have operations in Miami. I'm thinking the ICDR/AAA. The ICDR stands for the International Center for Dispute Resolution, which is attached to the American Arbitration Association, and there are other institutions that have expressed interest in having a presence. But even if they don't have a physical presence in Miami, the fact that there is a lot of traffic, air traffic, and the connection with the region is so easy, it also makes Miami an ideal supporting jurisdiction for arbitral proceedings. You know, even if Florida is not the juridical seat of an arbitration, it is very commonly the de facto place where the parties meet, where hearings are held, and so on and so forth. And just a final point, that infrastructure is also supported by organizations such as the International Law Section of the Florida Bar, that is constantly creating opportunities for practitioners and also for future lawyers. Is closely engaged with the universities that also have international dispute resolution programs. My own university, Florida International University, has a long-standing presence in the international dispute resolution arena. The University of Miami Law School also has an LLM in international arbitration and other initiatives. And there is an organization called the Miami International Arbitration Society, we call it MIAS, that has as its main mission the promotion of international arbitration in Miami. Tiffany, over to you.
Just a couple of comments in closing. You've covered so much ground, Manuel. You know, one of the things that we see a lot here, and Manuel mentioned the familiarity with both common and civil law and the infrastructure that we have here, the courts that specialize for international arbitration disputes. The other thing that we see a lot of are litigants coming to the United States to get information. So in the United States, we have a law that we refer to as 1782. That's the section 1782 of the code that allows litigants in international disputes to get information from US persons to assist in their dispute. So we have a lot of cases that come from Latin America seeking documents that may be in Florida through that code, and that's got its own special procedure. And the other thing is, you know, we really have been becoming such a center of financial growth in terms of, you know, actually like the financial sector itself has been growing so much that you've got a lot of law firms that have been coming down here and opening offices with 50, 100 attorneys in their office here. What they're calling it the Wall Street of the South now, which I think is quite a fun moniker. But, you know, that continues to lead as well to disputes. And just to give you a flavor, I have a dispute right now that's in court and that involves a Spanish company as the defendant, and the claimant is an Argentinian who's the representative for a bankrupt an entity in bankruptcy that is seeking to recover monies from the Spanish company. And they didn't sue them in Spain, they sued them right here in Miami. And I love how I say right here, even though I'm not physically in Miami at this moment. But Miami is just, it's still home. I sit as an arbitrator, and I have many disputes that are seated in Miami between plaintiffs and defendants, or complainants and respondents, claimants and respondents that are in Asia and in Latin America. So I've had several cases involving China, Hong Kong, and Japan on one side, and a company from a Latin American country on the other side that is seated in Miami. So it really has been growing as a center. In fact, I see the statistics show that internationally, Miami has 15% of the arbitrations. But as far as arbitrations that are seated in the US, we're starting to really hit up against New York City. So eventually we will, we may not beat them, but we'll be right on the level with them, because I think that there are certain things that Miami has to offer, especially for business relating to Latin America, that New York simply cannot compete with. So thank you. I think our time's up, but if anybody has questions, we'd be delighted to answer them at the end.
Thank you very much for that insightful discussion, Tiffany and Manuel. We love New York and Miami. Just want to put that out there equally. But Tiffany, your point is well noted. I would now like to introduce our speakers from the Law Society of Hong Kong. Ms. Olivia Kong is a partner at Wellington Legal. She's an experienced litigation solicitor who has worked in the United Kingdom and Hong Kong. She very much enjoys the buzz of litigation, and her practice focuses on contentious work. Olivia is a fellow member of the Hong Kong Institute of Arbitrators. We also have Ms. Louise Wong, who is an assistant solicitor at BMAC & Co. Solicitors in Hong Kong. She is admitted as a solicitor in England and Wales since 2005 and as a solicitor in Hong Kong since 2012. She's also the AIJA National Representative for Hong Kong and their Asia Pacific Regional Coordinator. Welcome, Olivia and Louise, and I will let you take it from here.
Hello, everyone. Hi, I think I will share my screen so that it's easier for everyone to understand what I'm trying to explain. So yes, Hong Kong is the gateway to China. So I'll explain why we're a gateway to China. Okay, I've decided to show some photographs of typical what people think about Hong Kong. So when you talk about Hong Kong, people would think about Kung Fu movies, great dim sum, going good clubbing, rugby sevens, good nightlife, good shopping. But apart from that, we have actually got a lot more than this. So I'll just give you some basic facts and figures. Hong Kong is actually got 7.5 million people, and we are the fourth most densely populated places in the world. We are a city and a special administrative region of China. Third in the Global Financial Centers Index, fourth on the UN Human Development Index, world's freest economy in the Economic Freedom of the World Index 2021 by Fraser Institute, and we are ranked 7th competitive economy by World Competitiveness Ranking 2021. So you can see we are a little dots there on the map. Okay, so I think before I go into now, I think it would be good for me to give you a very quick history of how we come to now. Hong Kong used to be a very small village, fishing village, and China lost the First Opium War against Britain, and the Treaty of Nanjing was signed in 1842. Hong Kong Island was ceded to Britain. After loss of the Second Opium War, Convention of Beijing was signed in 1860, and Kowloon Peninsula, a southward boundary strait, was then ceded to Britain. Then the Second Convention of Beijing was signed in 1898, and Kowloon Peninsula, north of Boundary Street and the New Territories, was leased to Britain for 99 years until 1997. Hong Kong was occupied by Japan during the World War II, and British administration resumed after World War II. In 1984, Britain signed the Sino-British Joint Declaration of China, and Hong Kong was handed over back to China on 1st of July, 1997. So as our president mentioned, we have got this one country, two systems. So I'm going to explain to you in more detail what is this. So you can see our basic law book there in yellow. It's actually a principle proposed by the Chinese leader Deng Xiaoping during negotiation with the British Prime Minister Margaret Thatcher over the expiration of the UK lease on the New Territories, including New Kowloon of Hong Kong in 1997. So basically the principle says Hong Kong can retain its established system under a high degree of autonomy for up to 50 years after handover to China. The principle has been implemented through the Basic Law of Hong Kong, which serves as the mini constitution of the region and consistent with the Sino-British Joint Declaration. So Hong Kong is responsible for its domestic affairs, including but not limited to the executive, legislative, and judicial power. And these powers are devolved from the Central People's Government under Basic Law. So why Hong Kong? So why invest in us? So because of the history, which I mentioned, we are basically a place where the East meets the West. And because we have a natural advantage of our location, it's very easy to travel to mainland China and to most of Asian cities it only takes about 5 hours flight. So a high-speed train connects Kowloon Station in Hong Kong with Shenzhen, and it takes about only like 25 minutes. Hong Kong has a free market economy, and we are as an international financial center. One thing I think is quite interesting, because I have actually lived in UK for 20 years, is a simple and low tax regime, which I'm going to talk more later. We also have a free flow of capital, and we have free trade. And we have a level playing field for foreign and local companies, and there is no barriers to trade. So as the president mentioned before, we are the only common law jurisdiction within China, and Hong Kong law is based on UK law. Both English and Chinese are official languages, and we are ranked 19th across 139 jurisdictions in the Rule of Law Index 2021, according to the World Justice Project. At the moment, we have got about 10,965 practicing Hong Kong solicitors and 941 local law firms, including my own. Hong Kong attracts lots of foreign lawyers and foreign law firms to practice the law of their home jurisdictions. And we have 82 registered foreign law firms from 22 jurisdictions and 1,463 registered foreign lawyers from 33 jurisdictions. So we are very global. So we'll now talk about, okay, so if you do want to invest in Hong Kong, and let's say you want to open a company here, how to do it? So foreigners are permitted to take complete control and ownership of their Hong Kong-based corporations. There is no requirement for a local resident to be involved. Hong Kong accepts almost all legal business categories. Money transfers and currency exchange are permitted for any types. Additionally, Hong Kong companies are not limited by the government to have bank accounts in any location. So you are allowed to have bank accounts anywhere. You're not required to open a Hong Kong bank account. And the types of companies, type of business in Hong Kong are like limited liability company, which is the most usual one, private company limited by shares, public company limited by shares, or company limited by guarantee. As I mentioned just now, the most common business vehicle in Hong Kong is a limited liability company. Apart from that, also there's sole proprietorship, partnership as in law firms, and other kinds of businesses like branch office or rep office. So in terms of company structure, say you want to really start a company here. So at least you need one director who is either a natural person or a body corporate. And whether Hong Kong resident or not, it's not the issue. You can even use nominee directors, and the maximum number of companies directors is unlimited. In terms of shareholders, you need at least one shareholder who is a natural person or body corporates, and again, can be Hong Kong residents or non-residents. Nominee shareholders and 100% foreign ownership allowed, and the sole director can act as a shareholder. In terms of company secretary, this is compulsory, and it can be Hong Kong local individual or corporate. And this one, a company director cannot be the company secretary. In terms of registered address, a compulsory local address for company registration in Hong Kong is needed. A PO box is not permitted. Share capital with a minimum of $1 and unlimited maximum. Bearer shares are not allowed. So apart from opening businesses, you can also do real estate investment. So Hong Kong allows foreigners to buy properties in Hong Kong and rent them out without any restriction as well. All land, this is actually quite interesting, all land is owned by the government in Hong Kong except St. John's Cathedral. So neither foreigners nor locals can purchase land on a freehold basis in Hong Kong. Foreign non-residents have no restrictions to apply for a property loan in Hong Kong, and foreigners need to pay two different kinds of stamp duties. Ad valorem stamp duty, which is a flat rate of 50% when buying residential property, and buyer stamp duty, which is charged at also a flat rate of 15% and needs to be added on top of the ad valorem duty. Foreigners cannot become permanent residents by purchase of real estate. So you can buy, but you cannot become a PR just because of purchase of properties. This is the interesting part. Hong is about the tax, one of the most tax-friendly system in the world. It's simple and it's low tax regime. So there are only 3 direct type of tax imposed in Hong Kong. It's the profit tax for first Hong Kong $2 million of profits, and it's 8.25%. Profits above that amount will be subject to tax rate of 16.5%. For unincorporated business, i.e. partnerships, sole proprietorships, there'll be a 2-tier tax rate of 7.5% and 15%. Salaries tax, standard rate, 15%. No VAT, no goods tax, no service tax, no sales tax, no capital gains tax, no tax on dividends, 0 tariff. So it's great when it comes to taxation. So I'm also a litigator, actually. So I'm also an arbitrator as well. So I would like to talk about Hong Kong as an international dispute resolution center. Hong Kong is ranked 3rd most preferred seat of arbitration worldwide in the International Arbitration Survey by Queen Mary University of London in 2021. We do have quite a few reputable and well-established local and international arbitration institutes. For example, Hong Kong International Arbitration Center, Hong Kong Institutes of Arbitrators, ICC, and CTEC. And obviously, the Law Society, we also have a panel of arbitrators established since September 2017. Apart from that, we have an electronic business-related arbitration and mediation called eBRAM. It's a non-profit company limited by guarantee established in 2018. And it's basically a one-stop, speedy, and cost-effective online dispute resolution and law tax service. So it basically helps to speed up the time and also efficiency in terms of cross-border deal making, dispute resolution, and also dispute arbitration. Hong Kong is an arbitration-friendly judiciary. We are pro-arbitration and minimum court interference as well. In terms of enforcement of award, because we are part of the New York Convention, so the awards in Hong Kong, you can enforce in more than 150 jurisdictions. And there is something interesting about enforcement of awards in mainland China, because we do have bilateral arrangements on mutual enforcement with mainland. So this is also possible. So another interesting point I would like to raise is the fact that there's exclusive interim measures arrangement with mainland China. So what it means that we do have interim measures which mainland can actually do property preservation for us, evidence preservation, and conduct preservation. So it's actually quite useful because it helps to stop lots of people from actually running between the 2 jurisdictions to avoid interim measures. And something new in Hong Kong, it's called third-party funding in arbitration. So in Hong Kong, basically contingency fee and conditional fees arrangements are prohibited. But since February 2019, parties lacking financial resources can now consider third-party funding in arbitration. So this is actually quite useful. Thank you very much, and I'll pass to Louise to continue.
Thank you very much, Neha and Olivia. Good morning, good afternoon, and good evening to all. Thank you for having me on this panel. It's a great honor to participate. In the midst of the world's first global pandemic in the digital age, Hong Kong climbed to 2nd place globally in the 2021 IMD World Digital Competitiveness Ranking. For the past few years, the Hong Kong government has committed around $14.1 billion to support developments in innovation and technology, I&T. It is estimated that Hong Kong's population will reach over 8.4 million by 2041. And so with a vision for a smart city, to enhance city management and improve people's quality of living, the Hong Kong government published the Smart City Blueprint in 2017 and a 2.0 version in 2020. And it's based on the Smart City Wheel developed by Dr. Boyd Cohen in 2012, and it covers 6 areas, which includes smart mobility, smart economy, which includes setting up of key technology collaborative platforms. Our friends in Hong Kong will be very familiar with the use of INT and artificial intelligence in the Leave Home Safe mobile app that currently has multiple functions, including a vaccine pass by scanning QR codes. And for taxi rides, it's powered by AI algorithm. It automatically records the time when users get out of a taxi purely by monitoring the motion patterns of its users. We have also seen the rise in fintech. Only last month, registrations for a digital payment system developed by the Hong Kong Monetary Authority, the Faster Payment System, enables the free transfer of money between bank accounts via mobile phones, crossed 10 million for the first time since its launch in September 2018. Developing a smart city not only can improve the quality of life for its residents, but also strengthens a city's competitiveness to attract global businesses, talent, and promote sustainable economic development. In 1998, the government has invested in essential infrastructure, including setting up the Innovation and Technology Fund with an initial 5 billion capital injection that helped establish important institutes, including Cyberport, Hong Kong Science Park, and 5 research and development centers that serve to drive and coordinate applied R&D in specific areas and promote its commercialization. In addition, the Hong Kong Productivity Council, a multidisciplinary organization, serves to enhance productivity and international competitiveness of Hong Kong enterprises through the provision of consultancy, training, and support of services to enterprises in Hong Kong. Cyberport is the digital technology flagship in the city that is wholly owned by the Hong Kong government facility and is essentially a business park with over 1,600 digital and technology companies, including established enterprises such as Microsoft, Lenovo, IBM. It provides advanced technology infrastructure that runs internship programs for ICT students, that is information communication technology, and incubation programs for new startups. As of October last year, Cyberport incubated 5 unicorns covering the areas of fintech, smart living, digital entertainment. And by unicorns, I mean a privately held startup company valued at over $1 billion US. In September last year, Cyberport signed a Memorandum of Understanding, MOU, with the Greater Bay Area Business School to expand its network of strategic partners and to provide startups, enterprises, and young entrepreneurs with more comprehensive training and information to support entrepreneurship and business development in the Greater Bay Area. Hong Kong Science Park is the flagship technology infrastructure and provides a campus-like environment 3 times the size of Cyberport. It's also home to about 900 technology enterprises and startups in areas such as artificial intelligence, with 4 unicorns having been incubated there so far. We have continued to see a rise in the number of startups in Hong Kong. 2020 figures show it rose to 6% from 2019. According to the 2020 Startup Survey by Invest Hong Kong, around 26% of startups were founded by non-locals. And from this table, you'll find that they are very diverse countries, with the top 3 from mainland China, United States, and the UK. There's also a third INT research cluster through the Hong Kong Shenzhen Innovation and Technology Park, which is a joint effort between the Hong Kong government and the Shenzhen Municipal People's Government when they signed an MOU in January 2017. The park area is 87 hectares, which is around 4 times the size of Hong Kong Science Park, and the first batch of facilities is expected to be completed in phases from 2024 to 2017. Once it's completed, the park will be the largest ever INT platform in Hong Kong. To understand the scale of the INT infrastructure in Hong Kong, the power of collaboration, we can turn to the Global Innovation Index 2020, which ranked the Guangzhou Shenzhen Hong Kong Science and Technology Cluster number 2, only 1 place behind the Tokyo Yokohama Science and Technology Cluster. The Belt and Road Initiative is a grand project to revive the ancient land and sea trading routes to boost trade and stimulate economic growth across Asia and beyond. Its full name is actually the Silk Road Economic Belt and the 21st Century Maritime Silk Road, which was announced 1 month apart from one another during Chinese President Xi Jinping's visit to Kazakhstan and Indonesia in 2013. Some 2,000 years ago, the Silk Road was the first ever link that connected the East and West and was the lifeblood of international trade. The belt recreates the old Silk Land route and refers to several land-based economic corridors spanning Central Asia and the Eurasian continent. The Greater Bay Area, GBA, on the other hand, is a region that comprises 9 mainland cities in Guangdong province, together with the 2 special administrative regions of Hong Kong and Macau, and covers 3 different legal systems, i.e. mainland China, Hong Kong, and Macau. The total population is over 86 million, and the total GDP is over $1,600 billion in 2020. As of May 2021, the GBA alone is home to 43 unicorn companies engaged mainly in e-commerce, health technology, robotics, financial technology, and biotech technology, worth a combined $1.1 trillion. In 2017, Hong Kong signed the arrangement between the National Development and Reform Commission and the government of Hong Kong SAR for advancing Hong Kong's full participation in and contribution to the Belt and Road Initiative with the National Development and Reform Commission. 26 collaboration measures were stated in the agreement to cover 6 key areas in which Hong Kong has a distinctive edge, including its dispute resolution service. 5 major goals of the Belt and Road Initiative: promote exchanges and dialogues between different cultures, improving connectivity, i.e. removing barriers of infrastructure facilities, financial integration, policy coordination to advance infrastructural development projects across borders, and finally to facilitate unimpeded trade and promote regional economic integration. Hong Kong's trade policy is also reflected in the Articles of the Basic Law, Hong Kong's mini constitution. For example, Article 13 of the Basic Law authorizes the Hong Kong SAR to conduct the relevant external affairs on its own, while the Central People's Government is responsible for foreign affairs relating to Hong Kong SAR. Article 116 confirms Hong Kong SAR's status as a separate customs territory and provides for its participation in international trade agreements. Article 96 provides for the Hong Kong SAR to make arrangements with foreign states for cooperation in legal and judicial affairs. Hong Kong actively supports and promotes a free, open, and stable multilateral trading system and is a founding member of the WTO. Hong Kong has signed 8 free trade agreements so far. And with the help of the Belt and Road Initiative and the Greater Bay Area, several new policies now give Hong Kong legal professions an even greater opportunity to expand their geographical reach and professional services beyond Hong Kong. The first is CEPA, the Closer Economic Partnership Agreement, and is a free trade agreement that aims at opening up mainland markets for Hong Kong goods and services. The Agreement on Trade and Services of the CEPA was amended in 2019, and it allows Hong Kong legal practitioners to obtain practice qualifications in the GBA by passing special examination, which I'll address in a minute. CEPA covers a wide range of legal services matters, including mode of operations of law firms such as non-partnership association, representative offices in the mainland, the geographic restrictions, scope of practice, and it covers requirements for law practicing individuals as well. And finally, RCEP, the Regional Comprehensive Economic Partnership Agreement. It was signed on 15th of November 2020 by 15 states, 10 ASEAN member states, and 5 ASEAN Free Trade Agreement partners. The agreement is the world's largest free trade agreement and covers a market of 2.2 billion with a combined GDP of $29.7 trillion. It was announced in February this year that Hong Kong submitted an application to join the 15-member RCEP agreement. RCEP seeks to establish clear and mutually advantageous rules to facilitate trade and investment, including participation in regional and global supply chains. Considering the countries involved, the wide range of trades and legal sectors covered, RCEP could bring immense opportunities, business opportunities to Hong Kong lawyers. Indeed, there are exceptional opportunities of Hong Kong lawyers who wish to practice in the Greater Bay Area. Hong Kong is the top 3 in terms of numbers of lawyers in the region. Hong Kong is designated with a pivotal role to enhance its status as an international finance center for international legal and dispute resolution services, according to the outlined development plan for GBA and the 14th 5-year plan. Another new policy was announced in October 2020 for pilot measures for Hong Kong and Macau legal practitioners to obtain mainland practice qualifications. Upon obtaining the practicing qualification, Hong Kong solicitors and barristers can provide legal services regarding specified civil and commercial affairs, including litigation and non-litigation businesses, using the mainland's applicable laws in the GBA, as well as enjoying the same privileges and obligations as mainland lawyers. Solicitors and barristers with 5 years of post-qualification experience are allowed to apply for the examination, as long as they remain they satisfy the remaining criteria. As such, young legal practitioners could capitalize on the development of the GBA and further enhance Hong Kong's legal services sector. And finally, the inaugural legal professional examination took place on the 31st of July 2021, and over 580 Hong Kong solicitors sat the examination. And the next GBA exam for 2022 will take place in Shenzhen on the 11th of June 2022. I believe that is my time, so I'll pass the virtual floor back to you again. Thank you.
Part of our panel. I want to introduce Mr. Amar Ali Nasir, who will be moderating all of this. He is the Vice President and Chairman of International Legal Affairs Committee of the Law Society of Hong Kong. He has been involved in various Law Society committees since about 1995, and he first joined the Law Society in 2005 and has been the Vice President since 2016. He is also the founder of Nasir Solicitors, and his main areas of practice are litigation, company commercial, Islamic finance, property trust, and notarial services. Amar Ali, you can take it over from here.
Thank you very much, Neha. Thank you very much to the participants for their very interesting and lively speech. And in fact, just now on the way home, I was walking past the pier, and there was a racing yacht, and its name was Unmute Now. So that reminds me that's become a very famous phrase during the last 3 years of us having to use Zoom. So I'd like to pose some questions to our speakers. I'll just start with Tiffany. You talked about arbitration. What is the law of the contract that you see most? I mean, of course, seat of arbitration is going to be Florida, but where you do have Florida, what's the most, of all the contracts, what's the law that's most chosen? In Hong Kong, we see either New York or Hong Kong or England and Wales. What do you see there?
Yeah, I see a lot of New York, and I'm part of New York as well. I see a lot of New York and Florida. Occasionally, I see UK. And most of the disputes that I deal with tend to involve, at least half, I would say, maybe not most, but at least half, tend to involve the CISG. So that's another interesting little point, particularly as if I recall correctly, the UK hasn't acceded to the CISG. There are a couple of, I think India has not either, and there are a couple of big ones that have not.
Yeah, and then some major changes going on now, which are coming into effect, which might have a lot of consequence for those parties that take it up, and then even if one party is not a contractual trait, so long as the other is, then that's a huge benefit to those the CISG new provisions that are coming into place. Thank you. What about, can you just, again, Tiffany, the Florida coins, can you just explain a bit more about them? Are they convertible? Do you have exchange? Are they easily converted to cash? Is there any tax for conversion of taxes? Are there any exchanges? And can foreigners hold these Florida coins?
These are all excellent questions, and I confess I am not the most well-versed on cryptocurrency, but I do believe that, as with any other crypto, you don't need to be a resident of Miami or of the United States or a citizen in order to have a city Miami coin. It should be fully fungible, just like any Bitcoin as well. I do know that they have apps for trading and things like that that are actually, like any other cryptocurrency that you may have.
Right.
I know that the miners can compete to mine the coins.
Right.
Through STX, which is the entity that's doing that work.
Oh, okay, that's interesting.
I wish I could be more.
No, it's always developing. I mean, what you tell us today, 6 months later, will be totally different. Because there's so many regulations, governments are constantly. But why I'm interested is because you've actually got a state-backed coin, whereas all of the coins we would deal with Hong Kong are mostly private-based coins. So when the state-backed coins, then it has a different economic effect to the value of the coin and the fungibility of the coin, whereas it's not, then of course you've got KYC issues and AML issues, anti-money laundering issues, which then add a complexity to the ownership and trading of those coins. So yeah, thank you very much for sharing that. Manuel, on property law, is it primarily based on common law and your own statutes, or is there elements of civil law that exist in legal systems within Florida?
No, it's a full common law system.
Right, with your own.
The reference that I made to civil law systems is because the surrounding jurisdictions are all civil law jurisdictions. You know, the jurisdiction where most of the foreign investors come from are civil law jurisdictions, and so you have necessary implications, but obviously not in the realm of property. You know, property will be regulated and governed by the local laws, which is purely a common law jurisdiction.
Right.
It's just that it's a jurisdiction that is somewhat educated also on the nuances of the other ones that are different.
Right. So do your courts, they deal with different civil law jurisdictions, and of course you follow the same rules of allowing foreign experts to come and give law on expert evidence on the laws of those jurisdictions. And that's what I think you said and Tiffany said about how experienced your courts are in receiving and handling foreign law elements within the decisions that they make, which would include having to consider civil law jurisprudential issues and then giving a judgment in a common law based system, take into account those foreign law elements, which is very interesting because in Hong Kong we have the same thing, and although with China we have a civil law system, we also have a lot of arbitrations here which might deal with matters of civil law, and so there is an element of commonality there. But it's interesting to know that you actually have such a variety of foreign law elements that your courts consider. I thought it was only like London that does that because of its policy to allow different, disputes to come within the English courts. But it seems that you also allow it within the Latin American sphere, at least.
Right. Let me just add something and take it a little bit further, if I may. And actually, I was coincidentally, I was at I was participating in legal proceedings in London 2 weeks ago. It was a foreign law issue, and I, I'm somewhat familiar with what British judges and lawyers do, and it was refreshing to be able to compare and see that. Well, London, I think it's at a special level of sophistication. UK judges are very technical, and they seem to have a really good understanding of how to process and how to analyze foreign law. But it was interesting, and the observation that I wanted to make now is that it's very comparable. But just one point that people don't think often about this. I've had experience in dealing with cases, for example, that there are corruption allegations. Anti-corruption is the new black, just to use that idiom.
Sure.
So what I've seen in American Florida judges is that, for example, a judge that needs to apply not all substantive foreign law, but also that had to apply, more specifically, anti-corruption statutes of another country, of a civil law, of a Latin American jurisdiction, have, by virtue of the how many cases are there in U.S. courts, I think they're creating this line of jurisprudence that is really interesting, because the perception of the foreign judge about the law that is of another country is different from what, say, the Venezuelan judge would rule. Yes. So the body of law that has been created in the U.S. interpreting the laws of a particular Latin American jurisdiction is so important, to the point that it in a way it overshadows what's going on in that jurisdiction, because a lot of the big cases are being handled not in the original jurisdiction but in the U.S.
Yes.
So that's something that I think a practitioner should have in mind when thinking about jurisdictions. Obviously, you want to engage with the country of origin where the law is from, but the real law, the living law is really being created overseas.
Right.
And that's true in London as well.
Absolutely. We also have that. We also have the very interesting concept here because, as you know, we have the English judges and Australian judges and Canadian judges sitting on our courts, and they bring in their immense experience into the Hong Kong courts in dealing with the Hong Kong jurisprudence. But what I've also noticed in one of my cases, the judges have an element of jurisprudential arbitrage, in the sense that where you had the wife's interest in England, it's called the Ettridge case, where a wife has property interest in the property and the husband mortgages it away. It's called the Ettridge principle, which is established in England. I had a case here in Hong Kong, and the dissenting judge in the Ettridge case took the major role in the Hong Kong case and passed a decision which everybody else follows. And I'm sure that arbitrage, where he became a majority decision, everybody followed it, can now use as a precedent, albeit persuasive, in England to possibly change Ettridge case, against them. So that's a very interesting concept. And then we've got Canadian judges, Australian judges, UK judges coming in. So that mix of jurisprudence then is exported back to those countries, and it also helps to develop ours. And I'm sure you also see that from what I've heard from you, Manuel, and the cases that you deal with, and also Tiffany. You must have seen that in arbitrations as well, because you have such a mix.
Yes, certainly. It's interesting, especially considering how much I work with the CISG, because in the CISG in the United States, you tend to see a big homebound tendency.
Right.
Judges are so, they're unfamiliar, and this is not really a Miami thing. This is more of across the board in the US. They tend to say, well, let's look to the US law on this issue. And I'm like, that's not what you're supposed to be doing. But when it comes to foreign law, they tend to be different. And especially in Florida, very similar to you, we have judges that are Latin American, and they're Cuban, they're Colombian, so there's definitely a lot of interchange there.
Yeah. Thank you so much. So perhaps I can ask Olivia. I think you missed out, Olivia. I'm not sure if you went through it very quickly, but you missed out that we don't have estate duty in Hong Kong.
Yes, I know. I thought they don't need to know that, though.
No, I know. But I mean, that's you can have $1 billion. You can transfer it to your family, and so the importance of that is we've now developed a special bureau that deals with family assets, family trusts, and of course, since it's headed up by government, then of course it has to go through the anti-money laundering provisions, but it's designed to allow families to structure their their provisions in trust, etc. And that's something that's extremely important. Olivia, can you also sort of highlight on EBRAM? It's also dealing with other aspects apart from what you've just said. Recently, you've had, it also allows translations, cloud storage.
Yeah, I think basically the EBRAM, it's developed to resolve disputes in a very speedy manner using technology. So it is actually quite a new thing. And it's actually developed by the government with the Law Society and the bar together. And I think this one may be a bit different from everyone else. It's not like the local courts or a general arbitration, but using technology to do that. So it's still quite new, isn't it?
Yes,
it's still quite new.
Very new.
It's a thing that we are trying to push forward especially in terms of online disputes, because it's getting more and more, because people use a lot of online activities these days, especially during COVID. So a lot of online disputes. So we are thinking ahead in terms of all these disputes, not just traditional commercial stuff. So yeah, it's going to be interesting, actually.
Yes.
Yeah.
Olivia, we've also had a special scheme only for $100 for COVID-related disputes. It's only
Yes, it's very
$100
cheap.
online.
$100 is Hong Kong, isn't it?
Yes, Hong Kong dollars. So that's what just over $10 US for the whole dispute.
So in some ways, I do not know how the lawyers can make money like this.
Yeah.
When we have got $100 Hong Kong to pay for a case. So it's good for the public, though, I have to say. Yeah.
And also in the APEC countries, I think US also APEC countries, it's one of the main key issues to access of justice for smaller businesses is the fact that the cost of litigation for small businesses would rather lose that loss rather than litigate. And EBRAM hopefully will enable a platform where online dispute resolutions can be looked at. You see, the main key to access to justice, as we see it in Hong Kong for smaller businesses, is that a small business has no time to waste money on legal fees, and therefore they feel that there is no justice in the system. And having no place to even go or look up adds to that frustration. And so EBRAM hopefully allows a landing page for somebody who has a concern, and at least it gets somewhere. And then if it's not addressed, then governments and other organizations can then pick up on those like APEC to ensure that there is access to justice. And I think EBRAM was actually developed for that purpose some time ago. You know, actually I spoke at the Papua New Guinea APEC conference when it was first introduced. So it is a broader concept. And of course, with arbitrations, it's helped because of COVID and the use of technology in COVID. And one more question, Olivia, is foreign lawyers, you've got a foreign lawyer in your practice. Foreign lawyers can practice any law of any jurisdiction within a Hong Kong firm. That might be interesting for you to know in the US, because if you go to a Hong Kong firm and you want to have a US lawyer or a BVI lawyer, I'm not sure which lawyer you have, Olivia, in yours.
BVI.
Yeah, there you go. Then you can obtain advice from a Hong Kong law firm on BVI law and you know, any law, whether be it civil law or common law. So within a Hong Kong law firm, you can have the provision of legal services from common law and civil law. We have people from New Zealand, Australia, Greece, you know, Spain, Italy, United States. United States probably the second largest group of foreign lawyers. So that might be of interest to your members. And finally, Louise, can you talk about the fact that we have one country, two systems, but actually everything we do with China has to be dealt with at a what would call an international treaty level, right? It's not as if you can simply, just because it's one country, two systems, it is actually like establishing a treaty, then have to go approve the treaty, and then you follow the treaty as it were with other countries. Louise?
I'm not sure if I understand the question.
Okay. I'm just trying to highlight the fact that, we might seem like one country, but actually we're two different jurisdictions legally. And if you have any agreements, like you have the ones that you mentioned, RICEP, etc., those are all based on sort of treaties that we have with mainland China, and they're established as treaties and then ratified by each party, as it would with an international agreement. So that's the unusual thing. I'm not sure if in the States, because you have a federal and local system, you have to have ratification of a treaty. You know,
actually, you mean international treaties?
No, I mean, I'm talking about your national, federal. When you have a federal law and you have a state law, how is it adopted? Is it adopted by a treaty and adoption, a ratification, or is it a different?
No, so federal law is passed by Congress.
Yes.
And it becomes the law of the land. There is a provision in the Constitution of the U.S. that basically says that, duly passed federal laws become the law of the land, which means, they're valid in the entire territory of the United States.
Right.
On the other hand, state laws that are made pursuant to what the state constitution or the state legislation or legal system provides will have, you know, limited scope of application. The question is, you know, what to do when there are conflicts. There is concurrent jurisdiction in some aspects between state and federal. You know, there is an array of statutes, of rules, of even you know, court decisions that have interpreted or have, you know, have sort of resolved the issue. Sometimes, you know, in civil litigation, you have that. You have the parties could choose whether to initiate the complaint in state or federal courts, and they make a strategic decision. It could be an advantage to a litigant because, you know, it might be that the type of litigation, you know, you may have better luck as plaintiff if you go on state court. It could be, on the other hand, for the defendant, a better strategy just to send it to, or you know, to ask for a dismissal in favor of federal court. You see that in the context of class action litigation very, very much. You see it also in some, you know, high stake cases. You see the move between one and the other.
Right.
But there's no need for any form of ratification. You know, clearly the federal issues trumps the state.
Yeah. So this is what I want to explain to the delegates is the fact that in China doesn't pass laws which become applicable across.
Right.
It can only enter Hong Kong through specific legal pathways. Otherwise,
yeah.
Hong Kong regulates itself, China regulates itself. And I just didn't want people to understand. We are lawyers. We're only talking about the local level, not the political level. But you know,
right.
at the it's a good
and
understanding.
there's another wrinkle there. Just quickly, Tiffany had mentioned the CISG, which is interesting. It's a treaty, has been, you know, ratified by the United States. It's the law of the land. The U.S. doesn't have any requirement that treaties have to be you have to go through approving legislation. Sometimes the issue that comes up is that the state law may, you know, the parties may ask the court apply the state law, and then the other side says, well, it should be the CISG what governs here. So you have there's a number of interesting cases on that, whether it's the laws of Florida or the statute of Florida or the CISG. The answer being, you know, the fact that the CISG is also, you know, state of Florida is also part of the CISG, you know, if the CISG will apply.
The answer
is the state of Florida. Sorry.
Right.
That's right.
No, sorry. The answer really is get a good lawyer.
That's the most important thing.
This is one that I come across all the time.
Yeah, in terms of who can practice and who can do legal work. Very, very restricted.
Tiffany, you were going to say, you were speaking about something? Your experience? You're muted, Tiffany.
Sorry, there seems to be a little bit of delay. I was just saying that on the topic of the CISG, the dispute that Professor Gomez was mentioning, or the conflict that Professor Gomez was mentioning, which is not really a conflict, but people perceive it as a conflict because they're not, you know, so familiar with it. Is something that I come across all the time with lawyers saying, but it says Florida law. And I'm, well, because the federal law supersedes, guess what?
Yeah.
So that's always an interesting experience, especially when I'm dealing with a lawyer on the opposing side who's not as familiar with the international.
Yeah, that also highlights the importance of the commercial lawyer advising his clients, or having at least a litigation lawyer on board during the commercial transactions who can advise the clients of future implications, and not, you know, so that's not in the paid. I mean, it's, if you're an auditor, it's the off-book item, right? So it's something that's important. Yeah, it'll be interesting to our delegates as well. I wanted to ask you, do you have third-party, we don't have it as much, of course it's beginning, but do you have third-party funding for arbitration and generally, and what's your experience of that?
Well, it has become trendy, as in most places. There was some, well, there are two levels, at the national level, because of some jurisdictions, some states had legislation against champerty and maintenance. There were some frictions regarding the adoption of third-party funding. That has really, it's a thing of the past. There are active funders operating. There's still some, the market moves in a very interesting way. Obviously, it's a lot easier and it's more dynamic in the international dispute resolution realm. There are third-party funders, for example, that are heavily focused on Latin America-related disputes, even though those disputes are being processed in the U.S., say in arbitral proceedings in the U.S. And I made quite a few. Every time, more and more funders that are much smaller than the usual suspects. For example, there are a couple of Brazilian funds that have a presence in Miami, or at least they have a front office in Miami. So you see some of that. In that sense, the downside is that it's not as regulated as in other places. The upside is that it's not prohibited. So it is possible. And also you have what what exists around the world. You have big third-party funding firms that basically deal with a big law firm. So most of the international law firms have portfolios with TPFs. So they're the ones screening the cases and getting the client energized to. So I think it's a good development. It's a good filter for high quality cases.
Okay.
Sorry, I know I'm a speaker, but I do want to ask a question.
Olivia, I've got a question for you. I've got a question for you from our US delegates. They want to know about your speech. You talked about St. John's Cathedral.
Yes.
Who owns St. John's Cathedral?
It's the church.
The church, yes, and it's freehold. Only freehold piece of land in Hong Kong. There were others. Hong Kong University. And one more, but yes, it's a church. And one more question is, what is the NFT space in Hong Kong like?
This is actually really hot at the moment. Everyone is trying to do an NFT. Yes, it's something going really big in Hong Kong, and I think it's worth jumping into. There is a market, and a lot of people in businesses actually try to, even luxurious goods owners, they try to create like earrings, clothes, everything in NFT. And also, for example, like photographs, art, designs and stuff, they also do NFT. So it's a very hot thing at the moment to do. And I think it's also metaverse as well. It's something that a lot of people are really jumping into.
Yes.
So yes.
I have another question. I have another question from the US, which is for Louise, which is that what is the opportunity for US lawyers who are in litigation in Hong Kong who speak only English? That's an easy one.
Well, they can also qualify, take the OLQE, the Overseas Qualification Examination, and then qualify as a Hong Kong lawyer.
Yeah.
So that would also open a lot of opportunities for them as well. So they're not only restricted to practice in their jurisdiction, but also in Hong Kong as well.
Yeah. So once you qualify as a Hong Kong lawyer, which is only one exam with many papers, you can then go before the courts, and in courts you can choose to speak English or Chinese. And if you speak only English, you'll get translators. I'm sure in Florida it's the same. If you have Spanish speakers, you have translators there as well.
And the great thing about setting the OLQ is that once you pass, then you don't have to go through the training again. So that's so easy. Yeah, once you pass them all, of course.
And of course, if you're a US lawyer, you can work as a US lawyer within a Hong Kong firm and deal with all the arbitrations you want around the world and in Hong Kong in English, or whichever language you wish. Is it advisable to hire a Hong Kong lawyer if foreign individual wants to participate in the Hong Kong NFT art space? Foreign individual wants to go into the NFT art space. Is it important to hire a Hong Kong lawyer?
Yes, it's
is. Always
and
good to hire a lawyer.
Yeah, exactly. Although there are not a lot of NFT lawyers, but my law firm, we do have an NFT lawyer.
Okay.
It's actually quite a niche area. It's those IP lawyers that go even more niche to NFT. So yes, it's the big thing.
And it's developing. And we have one more question for our US speakers, which is from Olivia herself, and she wants to know a lot more about class action in US. I know we're over time, but I'll cut my closing to 1 minute.
Can I rephrase more detail about this class action? Because in Hong Kong we don't have. I want to know, what do you think about class action? Is it a good thing or is it a bad thing?
Well, that's a big question. It is in the most neutral way. Well, the upside of having it is, judicial economy. You can aggregate a large number of cases and dispose a large number of cases in a single proceeding. So that's good. It also allows low value dispute, low value claims to be aggregated. For example, the customer, the individual who has only $100 claim would not be able to seek redress in court if it weren't for class actions. That allows 1 million people with the same claim to band together. It's also good for the lawyers because you get your fees accordingly. The downside of it, depending on who you ask, is that there is an abuse of a class action system. Something that the class action device has been used to extort corporations. The lawyers are the ones driving class actions. The fees are also a problem because sometimes people get $5 coupons, or that you get a $5 reward, but the lawyer gets $50 million because they get a percentage. So there are distortions. There is a statute, a federal statute called the Class Action Fairness Act that was passed years ago that tried to correct those distortions. There is also a very important body of court decisions that have tried to correct the distortions. There are class action statutes in different states. So the federal class action is guided by a rule called Rule 23 of the Federal Rules of Civil Procedure. So it's a very complex system that I think has good things and bad things. And interestingly, it has been used as a reference by many countries around the world. So the U.S., the U.S.'s gift to the world in a way of litigation was this idea of, yes, you can aggregate a lot of proceedings in a single case to a single judge without the problems that joinder and these other traditional litigation mechanisms had.
Hey,
I hope that was helpful.
Thank you.
To add just briefly,
yes,
to Professor Gomez's very knowledgeable base there. I also think that it's a great tool to sort of equalize corporate power, because so many times you have these very large corporations that get away with this harm because for that one person, it's just too much of a drag, but really what they're doing is allowing them to reap and profit off something that they shouldn't be doing, but because the individualized harm is so small, right? So one of the things that is a conversation that's been happening with all of the supply chain issues that we're seeing, there has been some talk of a class action. It's something that I've been suggesting for quite a while, to sort of rectify some of the abuses from the shipping lines that we're seeing in the United States lately, with all of these sort of supply chain issues that the world has been experiencing.
Okay, we have other questions, but I can't get them because our time is out. Neha, I'm going to keep mine to half a minute or quarter of a minute. So over to you, Neha, to give us a closing.
Sure. I just want to thank everyone for their time and diligence and for educating us on these important issues, within your respective jurisdictions. We certainly do hope to continue conversations such as this one between the two major gateways of this world, Hong Kong and Miami. And I will hand that over to you now, Amirali, to close us off.
Thank you, Neha. I'd really like to thank the speakers for making the seminar very successful and bringing to us information about these gateways to economies and opportunities for businesses and individuals. And I see a lot of commonality in our different jurisdictions, and I think it's also now allowed us to learn a lot from each other to apply them innovatively in other areas. I see also a lot of similarities in cultural diversity. I'm sure love of food, art and culture. And I look forward to further collaboration with you in other areas. And I will end by saying good day, good night. Thank you very much.